Good morning, everyone. Thank you for joining us for the Regulatory Relief webinar. Our presenter this morning is Brendan Owens, Esquire, of the law firm of Stafford, Owens, Pillar, Murnane, Kelleher, and Trombley. And I'm going to turn the presentation over to Brendan in a moment. At the end or during the presentation, should you have questions, we ask that you type them into the question box on your control panel. We will not be taking any audio questions today, so only typed questions. Brendan, take it away.
Okay. All right, so my name's Brendan Owens. I work with Adirondack Health Institute. Specifically, I worked with them on parts of the application for DSRIP and the regulatory relief portion. So I'm going to review the New York State regulatory relief process and some of the highlights of DOH's responses to AHI's waiver request. I won't be providing any legal advice today, and several times throughout the presentation I'll highlight areas where you really need to talk to your legal counsel regarding some of these issues. So the structure of the presentation will start with state law, and there I'll discuss the waivers that were requested and the results. I'll also touch upon some state statutes that have an impact on DSRIP and the fact that AHI could not get waivers of those. Second, I'll discuss federal law. So we'll briefly touch on some of the issues you must be on the lookout for in your projects. I'll focus on the fact that you can't get waivers of federal law, so you must be cognizant to avoid certain federal law pitfalls. You will need to consult with your counsel, or AHI will be happy to direct you to other counsel to work with on these federal law issues. And you just always have to remember, with federal law, compliance for the project is your responsibility. So for state law, there are two key points. First, there are no waivers of state statutory requirements. And second, on behalf of its partners, AHI requested and received numerous important waivers of state regulations. So a quick note on state statutes. New York has restrictive statutes on sharing medical information. This is especially stringent for HIV and mental health information. And in these areas, New York State requires consent from the patient for most disclosures. DSRIP does not change this. So the risk here is that DOH occasionally there'll be an enforcement action. There can be joint commission issues, but mostly the risk is that the violation of state consent laws can lead to lawsuits by patients. So AHI, the state, and other PPSs are taking some action to address the state law consent issue. We requested a waiver of really actually requesting that DOH create a waiver or create a regulation to make a single consent for the PPS permissible to address all of these consent issues under state law. As anticipated, the state rejected that, but it did say that state agencies are collaborating to create a consent model. So there are two levels of data at play here. The first is the state sharing patient identifiable data with the PPS to do analytics. There's a data exchange application agreement that has already been promulgated and that AHI has already entered into. But the second level is with PPS participants sharing information amongst themselves for treatment, payment, healthcare operations. And there, that's where these consent issues can come into play. So we're just on the lookout for a consent document to be promulgated. I think there are two ways that the state could go about that. One is they could go for an opt-out model where, unless the patient opts out of providing, of allowing their information to be provided to providers without the PPS, then the information can be provided. That's pretty unlikely. I think that the state will go in that direction. The other option is for the first provider in the PPS that treats a patient to obtain a consent from that patient to allow sharing information throughout the PPS. Those are kind of the two models I think you could possibly see, but in any event, that hasn't been addressed through a waiver because it's a statutory requirement. So we're just waiting for further action by the state on that. So state agencies were given authority to waive certain regulations to accomplish DSRIP. When AHI requested its waivers, it reviewed the requirements outlined on this slide. And it also reviewed its project applications. And it tried to take what all the participants were doing in their project applications and tried to request waivers that were very specific to those projects. And this strategy was very successful. So the state received 536 waiver requests from 24 PPSs. It approved 243, it denied 95, determined that 97 were not needed. 23 are still pending, 31 are approvable on a case-by-case basis, and for 47 of them, more information was needed. AHI requested 91 waivers. It had 34 approved, 13 approvable, 19 more information needed, 16 were denied, 7 there was no waiver needed, the state determined, and 3 a determination is still pending. So this means AHI received about 13.9% of all the waivers received in the entire state. There are 24 PPSs, so proportionally AHI should have only received around 5%. Action needs to be taken by individual DSRIP participants on some of the approved items. Action needs to be taken on all of the approvable items, and action also needs to be taken on all the more information needed waivers. So that means that if you look through the whole list of waivers and there's a waiver you would like to utilize and it's either approved, approvable, or more information needed, you should contact AHI to ask how to proceed with utilizing that waiver. AHI may direct you back to counsel in certain cases, or it may direct you to a contact at New York State. It's also worth noting that the waiver process is rolling. So if you determine during the course of your project that you need an additional waiver, it can be requested. I would note that we didn't expect to succeed on all of the waivers that were requested, especially some of the items that were denied or deemed no waiver needed. In certain cases, we just requested them to receive clarity from the state. So I'm going to discuss a couple of items that were approved. So the first item I'd like to touch on is centralized credentialing repository. So we wanted participants that may share the services of providers to have a single credentialing process. For instance, for telemedicine, there are provisions that allow the originating site to rely on the distant site's credentialing of its providers when provisioning those services. We crafted a waiver to try to achieve something similar for providers within the PPS. That is, that one provider in the PPS could rely on the credentialing of another provider. The state didn't grant that, but what they did grant was to allow a centralized repository for credentialing. So this is not dissimilar to an agreement with a credentialing agent some of you may be familiar with. What this waiver allows the PPS to do is to create a centralized database of credentialing information for providers within the PPS, and then different participants in the PPS, if they're going to utilize the services of another physician within their site, can use the information in that database to more rapidly credential the provider. The next item is revenue sharing. Here, many PPSs requested this. It was approved, and it simply allows incentive payments to be held by the lead and distributed to others without the lead being treated as the operator of that provider due to holding those funds. The next item was CON components. Here, AHI requested that PPS projects be fully waived through the CON process. That was denied, but DOH did accelerate the process by removing the public need and financial feasibility components for aspects of the PPS or aspects of the DSRIP project that have been approved. The next item that was approved that I'd like to touch on is off-site services and home visits. So here the PPS requested the ability for Article 28 entities, that is hospitals, FQHCs, diagnostic and treatment centers, to be able to send physicians out of the service area or approve sites of service. This was approved, but DOH must be notified of the plan. So if you utilize this waiver, then you must present a plan to the state showing the services. Currently, this could actually not be reimbursed. So practically, the DSRIP incentive payment would need to exceed the cost of the Article 28 institution in order for sending practitioners out of the service area to be economical. However, there may be provision of care reasons to do so regardless. And the next item, which was a large item, was the integrated services. So at the time AHI applied for, presented its DSRIP application, the integrated services regulations were in draft form. At about the same time that the application was submitted, or slightly before the integrated services regulations were finalized. In its application, AHI asked for finalization of the regulations. It also asked for accelerated processing of integrated services applications or waivers of the need for an application. It also asked for the co-location prohibition to be waived so that an application would be necessary in some cases. So what DOH did was it waived co-location for certain providers. So many of you will recall that dual licensure is necessary where a clinic or diagnostic and treatment center for mental health provides more than 10,000 mental health visits, or those mental health visits are 30% of the annual visits for that provider. However, even if mental health visits constitute 30% of the annual visits, a program with 2,000 visits wasn't required to be licensed. So that's a little bit complicated. What DOH did is for DSRIP projects, providers are permitted to integrate primary care and behavioral health under a single license or certification, so long as the service to be added is no more than 49% of the provider's total annual visits. That's called the DSRIP Project 3A1 licensor threshold. So as long as it's 49% of total annual visits and the patient initially presents to the provider for a service authorized by that provider's license. So you have two requirements. The provider must also comply with physical plant standards. So the provider needs to determine whether the requirement regarding initial presentation for a licensed service. Let me just back up a little bit. So the requirement regarding initial presentation for a licensed service means that the provider needs to determine whether it's better to use the integrated services licensor process or the DSRIP licensor threshold. So that's a determination that each provider needs to make, but this waiver does give some room to avoid going through the integrated services regulations in certain cases. So the next 3 slides summarize the DSRIP licensure threshold rule in a little bit more detail, and it expands it out to OASIS facilities. So I'll now discuss items that the agencies determined were approvable. Here's where we got a little bit more creative in the hopes that some of these might be helpful. The agencies indicated that a waiver may be available depending on what kind of plan a participant comes up with, or the PPS as a whole in certain cases. So I'm just going to provide a couple of examples of what approvable waiver requests were. So there's a requirement for a nurse to fill out a PRI form for a continued stay in a health-related facility. AHI felt that there may be some use in having a PPS develop a form for services utilization that would have broader applicability throughout the PPS. So DOH said that if the PPS as a whole wanted to develop such a form, that they would take a look at it. The next item is CON review of health information technology. The PPS requested a waiver pertaining to CON review of HIT in existing medical facilities. The department said that it would review each project on a case-by-case basis, and that this was approvable if the PPS contacts OHIT for approval. So the next item is dual admission to central and satellite facilities. So this came through a process where a OASIS regulated provider contacted me directly. The issue is that in certain cases, a patient may require simultaneous outpatient treatment by 2 providers that provide separate outpatient services. Currently, a patient can only be admitted to one entity and be paid. This would allow dual admission, but there must be protocols to ensure the continuation of net deficit financing in compliance with the federal reporting requirements. So a provider wishing to utilize this waiver must provide more information to Tricia Allen at the address indicated above. And again, this is a case where AHI will work with the provider to facilitate that, and the provider may wish to have the plan they come up with reviewed by their independent legal counsel. This is an example of where the state, in response to a waiver, indicated that it needed more information. More information, I think, is similar to a waiver request being approvable. I would say it's a little bit less positive. So in this case, AHI envisioned that some providers may wish to provide services currently licensed at a central facility to an outlying facility on a permanent or floating basis. Similarly to the last item, OASIS indicated that it needed more information. The next item is administrative services. So this is another category where no waiver was determined to be needed. In certain cases, AHI requested a waiver to receive clarity on certain items. This is one of those cases. So the concern was that a PPS could be seen as performing administrative services for a participant by administering the PPS. DOH simply confirms that PPS administration is not administration of the facility. Finally, there are some items where there's a determination pending. So we requested automatic service area expansion for home health agencies, We wanted the service area to be concurrent with the geographic area of the PPS. So we requested this to allow home health agencies to operate throughout the PPS service area. And this is really to acknowledge that our providers, or AHI's providers, have a large rural area where patients may travel from a great distance to a central hospital, and further, that DSRIP may result in higher usage of home health care. So for DSRIP participants that are involved in home health care, this could be useful in terms of avoiding a step in expanding the service area due to DSRIP. Here, a determination is still pending, so I imagine sometime before the fall, they will give a final determination on that request. It may be transformed into an approvable request, in which case there may be some action needed on the part of the home health agencies that want to utilize it. So that's just a representative sample of the different waivers. You'll need to work with your counsel in AHI to utilize some of these. New York State has a regulatory relief website in planning. There's also more information on waivers at the link on this slide. The next item I would like to touch on is federal law. So the important takeaway here is that there are no waivers of federal law due to DSRIP. So each participant must comply with all federal laws. I'm going to touch on the bolded items, antitrust, Stark, anti-kickback, but you also need to be aware of HIPAA requirements, EMTALA, and Medicare and Medicaid rules. So the first item, antitrust law. Antitrust prohibits monopolies and price fixing. It's enforced by both the state and the federal government. At the state level, it's the state attorney general. At the federal level, it's the Federal Trade Commission, the FTC. What the state did is it created COPA, which is a state law process that provides immunity from action by the New York State Attorney General. New York State Department of Health has a website for COPA that you can get more information about it on. COPA does not and has never provided immunity from federal action. And in fact, the federal government has had longstanding guidance on cooperative efforts amongst competitors in the healthcare industry. So the FTC guidance on cooperation amongst competitors in the healthcare industry first recognizes that there can be pro-competitive effects of collaboration amongst providers in the healthcare industry. That is, improvement of care or reduction of cost, all of those sort of things. It then analyzes collaborative agreements with regard to whether the collaboration is likely to have anti-competitive effects, and if so, whether the collaboration's potential pro-competitive efficiencies are likely to outweigh those effects. So in essence, the FTC looks at the benefits and weighs it against the risks of the collaboration. So the greater the likely anti-competitive effects, the greater the likely efficiency must be for the collaboration to pass muster. So COPA has no effect on the FTC's analysis of collaboration between healthcare providers. The goal of COPA was to say to the world that New York State was certifying that there was a pro-competitive impact of the proposed organization. The FTC looked at COPA and said it was suspicious of COPA because it deemed it unnecessary if a group of providers were following its prior advice. So AHI applied for a COPA. The FTC then sent a letter responding to the COPA program as a whole, and it said it had concerns regarding the need for COPA because COPA is unnecessary if a group of providers followed its prior advice. There are a couple key points in that letter that the FTC sent. That is that clinical integration to benefit consumers remains legal. DSRIP participants sharing competitively sensitive information to help other DSRIP participants achieve better outcomes in private payer negotiations remains illegal, and DSRIP participants jointly negotiating with payers remains suspect. So just a couple of points. Competitively sensitive information means information about how much a payer will pay. So that's the information that shouldn't be shared. Pro-competitive means collaboration to bring down prices. So the goal of DSRIP is to reduce costs to Medicaid by reducing unnecessary hospital readmissions. Anti-competitive means collaboration to see how much you can charge a payer. So if you're providing information to other DSRIP participants on how much a payer will pay or how much you can charge a payer, in order to charge that payer more, then there may be an issue. The FTC is also concerned that sharing for Medicaid purposes could lead to sharing for private payers because there's some information overlap. If there are any concerns about this, this is an area where you really need to contact your counsel to get an opinion on whether what you're doing is permissible under the antitrust laws. The next item I'll touch on really quickly is the Stark and anti-kickback statutes. So Stark says that a physician cannot make a referral to a healthcare entity if the physician or his or her family member has a financial relationship with that entity, unless an exception applies. The anti-kickback statute prohibits the exchange of anything of value in an effort to induce the volume, which is the number, or the value, which is the type of referrals for healthcare services covered under a federal program. The key point here is that PPS participants will be referring patients to other providers within the PPS. This means that any arrangements where money, services, equipment, office space, or anything of value is being exchanged amongst providers, it must be analyzed to ensure it complies with Stark and AKS. AHI is not responsible for doing this, so each participant must really conduct its own due diligence. The key message here is that when you look at a situation and there is a referral, especially if it's to a physician, you should contact an attorney or a compliance officer or someone with expertise in this area, especially if there is any financial relationship between the institution and the other party. So AHI obtained 34 waivers of New York State regulations. Some waivers will require more work on your part to utilize. It's important to remember that you must still comply with all state statutes and any regulation that was not waived by the agencies. And finally, DSRIP participants must still comply with all federal laws. The DSRIP program did not change that. Thank you very much. Again, my name is Brendan Owens. I'll remain on the line for some time to take questions now.
Thank you, Brendan. All right, so if anybody who's on the webinar has questions, please type them into your question box on your control panel, and then we will work on addressing them. At this moment, we're going to take a couple-minute pause just for some questions to come in. All right, so our first question.
The first question is, does the DSRIP waiver address any of the issues involved when two Article 28 want to co-locate and offer services out of the same physical space?
So the licensure threshold waiver doesn't apply to that because they both have the same type of license. The issue that Article 28's run into is service area generally, and there are a couple of solutions to that that generally involve that are pretty specific to the way that you move your providers into the co-located space. What you can often do is utilize a subsidiary entity to move to have a service area that overlaps with the provider whose space you're co-locating in. So that's really an area where you need to contact legal counsel to determine how best to go about doing that, but that's basically the framework of how two Article 28s generally would share a clinic space, especially for types of providers that they don't currently have, or that one of them doesn't currently have.
Okay, our next question, which I'm going to read verbatim, says, quote, AHI is not responsible for stark and anti-kickback amongst the PPS, question mark. However, I would assume we have a duty to inform them and point them in the right direction, end quote. So, Brendan, if you need more clarification on that, let me know and we can ask the person who asked the question to clarify further.
Yeah, so, I mean, really the issue is that AHI knows what the projects are, but doesn't have specific information about what the other financial relationships that an entity may have with a provider are. So that's really where the participant needs to issue spot these stark and anti-kickback statute issues. I think AHI and someone from AHI can certainly chime in, but I think AHI would certainly direct you to someone to talk to about a specific issue if you're concerned, but it just cannot assume the role of having knowledge about a participants' own internal financial arrangements with providers.
Brendan, this is Kathy Homke. I would agree. I think that the message is that AHI is not responsible for this. However, actually, from AHI perspective, it does bring to mind OMIG and compliance. So I think this might be something we need to investigate in terms of our responsibility should this become a compliance issue, correct?
Well, so, AHI, in terms of its own OMIG program, is responsible for compliance in its role as a PPS. These stark issues and anti-kickback statute issues are not really PPS issues, they're project-based issues, and the projects are owned by the providers. So the compliance officer at AHI may be a good contact person, but certainly that compliance officer cannot possibly be responsible for having knowledge of internal information at a participant regarding financial arrangements with providers.
So essentially what I'm hearing is that while AHI is not responsible, that each of our PPS participants should really contact their legal representative to really address any issues regarding financial relationship between that institution and other parties.
Exactly.